Dr. Payal Thaure, Head of the Department, Postgraduate Teaching Department of Law, and all my colleagues and participants. Today, we all have gathered here for national webinar on judicial introspection of doctrine of essential religious practices. As we all know, that though freedom of religion is guaranteed under the Constitution, but as religion governs all aspects of human life, from birth to death, including the social relationship, sometimes legal relationship as well. So, whether in this legal responsible age of social welfare and law being an instrument of social transformation, to what extent does the freedom of religion can be guaranteed and protected by the constitution and law as such? For that, the midway has been evolved by the code in form of essential religious practices, and thereby our honorable esteemed speaker is going to throw light upon the nature and scope of the essential religious practices evolved by the judiciary as now I will hand over the mic to the coordinator of this webinar, Vidhi. Over to you, Vidhi.
Thank you so much, sir. A very good morning to all. I, Vidhi Barne, first year student of Postgraduate Teaching Department of Law, Rashtrasant Tukadoji Maharaj Nagpur University, feel privileged to welcome you all on today's national webinar on Essential Religious Practices Judicial Introspection, organized by Postgraduate Teaching Department of Law, Rashtrasant University, associated with Center for Women Studies and Development, Rashtrasant Tukadoji Maharaj Nagpur University. Before we commence today's session, here are a few important instructions for the participants. That question answer session will commence in the end of the webinar, and all the participants of today's webinar are requested to post their questions in the chat box. Also, the link of feedback form shall be provided at the end of the webinar in the chat box, and e-certificates will be provided to the participants only after receiving a duly filled feedback form. Now, I invite Dr. Payal Thaure ma'am, Head of Postgraduate Teaching Department of Law, Rashtrasant Tukadoji Maharaj Nagpur University, Nagpur, to deliver the welcome address. Over to you, ma'am.
Thank you, Vidhi. Honorable, respected Dr. Sanjay Jain, sir, all my dear colleagues and participants, I extend my warm greetings for today's afternoon. Of course, it is always a pleasure to listen to Dr. Sanjay Jain. Being a prestigious alumni of our department, it is always nice, to host him in the department in various academic activities. And this is one such activity today we are going to have, that is a national webinar on the topic of essential religious practices. As Girish has already explained the objective behind this particular webinar, as this is one of the recent issues, a hijab issue which is going on. So being a law person, it is always necessary to look into the situation from all perspectives, whether something is right or something is wrong. And I'm sure that after today's lecture, we all will have that clear insight about what the essential religious practices are and how it should get accommodated into uh, you know uh, into validating it from the legal perspective. So I extend my warm greetings to today's resource person, Dr. Jain sir. Sir, thank you so much for gracefully accepting our invitation. And I would also like to inform you, sir, that we are having a series of like 10 webinar series wherein in most of these webinars, all our alumni are gracefully accepting our invitation and delivering their thoughts, their opinions, their experiences, their valuable knowledge to all my participants. So I'm looking forward for today's webinar as well. So thank you so much, sir. Over to you, Vidhi.
Thank you so much, ma'am. I am glad to introduce our eminent resource person and our dear alumni, Dr. Sanjay Jain, sir. Sir is professor and officiating principal at the ILS Law College, Pune. Sir has completed LLB, LLM, and PhD in feminism and constitutional law from Rashtrasanta Tukadoji Maharaj Nagpur University, Nagpur. Sir has started teaching in Department of Law, Nagpur University, and later he became lecturer in law in Bharati New Law College in 1997. And since the last 11 years, he is at the ILS Law College, Pune. His total teaching experience is 24 years. Sir has been recently appointed as Country Advisor India, Inclusive Public Space, Law, Universality and Difference in the Accessibility of Streets project for the period 2020 and 2023, and also project director for the project funded by ICSSR Delhi. Sir has received number of awards, among which are Most Efficient Disabled Employee National Award at the auspicious hands of the then President of India, Honorable Dr. APJ Abdul Kalam in 2004. Then Best Employee with Disability 2017 award from Swaraj Viklang Seva Samiti, Allahabad. And also Mrs. Pilo Dorav Khambata Memorial Award 1999 to 2000 as an outstanding blind employee by NAB India. Sir has published 6 books and a number of articles in books and various journals. The most significant among his books are Critical Essays on Disability Rights Jurisprudence, Combating Exclusion, Embracing Inclusion, Bloomsburg 2022. Basic Structure Constitutionalism, Revisiting Keshavananda Bharati, co-edit 2011. Recently, Sir has finished the editing of the edition of V.D. Mahajan's Constitutional Law book to be published by EBC Lucknow. Sir is also a disability rights activist. Also, Sir has participated and attended in more than 150 international, national, state level seminars, conferences, and workshops. Sir has presented dozens of papers and has delivered more than 100 lectures as resource person in the fields of constitutional law, feminism, disability rights in various prominent institutions, law colleges, and universities throughout India. I once again welcome you, sir, and hand over the mic to you.
Uh, Please continue. Hello.
Yes, sir, you're audible.
Okay. So, should I begin?
Yes,
Sir,
sir.
yes, sir, please.
Okay. The head of the Department of Law, RSTM University, Thaure Madam, my friend Girish Kulkarni, other colleagues in Department of Law, dear student friends and other delegates of this national webinar. It is always a pleasure to come back to one's alma mater and, try and give whatever one can. And though Nagpur is very warm by weather, the love and affection of Nagpur is equally warm. And therefore, I am always happy to be the part of any activity associated with the department. Of course, it goes without saying that a lot of credit goes to Department of Law in general and my mentor and my teacher, late Professor Dr. Deshpande, under whose mentorship we all were very fortunate to be groomed, very fortunate to be trained. And whatever little knowledge of subject we are able to have, I think, is mainly due to his efforts and his grooming. So let me remember my teacher, Dr. Deshpande, as usual, and let me go into the subject. Now I'm asked to engage with a very controversial doctrine associated with interpretation of Articles 25 and 26 of Constitution of India. And that doctrine is known as Essential Religious Practices Doctrine, which is also, in short, known as Doctrine of ERP. Now, when you read Article 25 and 26, particularly when you have a close look at the text of Articles 25 and 26, do you find anything like essential religious practices is a question. And no matter how closely you read these two articles, neither implicitly nor explicitly, there is any hint of the presence of or the appearance of this doctrine, even in spirit, in these two articles, is my hypothesis and is my assumption. And I'm going to proceed with this assumption. I'm proceeding with the assumption that Articles 25 and 26 does not, or do not, rather, do not, Articles 25 and 26 do not recognize a doctrine called essential religious practices. There is no evidence, intrinsic or extrinsic, in the text of both these articles to arrive at this conclusion. And friends, when I say this, now there may be already a storm in a cup of tea, because I'm stirring the pot. I'm trying to question something which is almost as determined as the shlokas of Gita. Whenever you read Articles 25 and 26, invariably you talk about essential religious practices. And therefore, when I superimpose my assumption that there is nothing in Articles 25 and 26 to even implicitly suggest for the existence of such a doctrine, you may wonder on what basis I am making such a tall claim. And I would recall my teacher, Dr. Deshpande, who used to tell us, used to tell me also, don't take anything seriously than the letters of the Constitution. And at the same time, he was also used to caution us that when you take into account the letters of the Constitution, read the letters in spirit. Don't read them as black letters. And indeed, I am reading Articles 25 and 26 in spirit. I'm not reading them as some kind of grouping of words or letters. And still, my conviction is, and my very considered opinion is, that these two articles do not have any place for the doctrine of essential religious practices. Now you may ask, or you may wonder, on what basis I'm making this claim. So I have two rationales. First rationale is the textual rationale. The text of these articles does not mention the so-called essential religious practices doctrine. And my second rationale is that cherry picking of one single quotation from the speech of Dr. Ambedkar, which he delivered in, I think, on 2nd December 1948, if I'm right. And then based on that quotation, carving out a doctrine to confine the scope of Articles 25 and 26 is unjustified, because when Dr. Ambedkar was making his speech in the Constituent Assembly, it was a speech to explain the concept of freedom of religion. It was a speech to emphasize how religion is all pervasive, how the impact of religion on our society is all pervasive, and how, unlike West, it is not possible to wall off state and religion, how it is difficult to argue for a complete compartmentalization between the state and the uh, church, or the state and the temples, if I were to say so. In other words, wall thesis, which is the backbone of the First Amendment, the Priest Establishment Clause. Such understanding is not possible in India. So that was the context of Dr. Ambedkar's speech. And Dr. Ambedkar was trying to simply say that, okay, what is essentially religious? What is essentially religious must only deserve protection under the Constitution, because if you use the rubric religious in a loose manner, then from cradle to grave, almost every aspect of our life in India is governed by religion, and therefore you will not require any other fundamental right. You can read everything in freedom of religion. And he cautioned against such an expansive interpretation. He said that what is essentially religious. So there is a big difference, friends, between saying what is essentially religious and a practice which is essential to the exercise of a particular religion, or to the worship a particular religion. Of course, when Dr. Ambedkar was talking about what is essentially religious, he was making a very simple point. He was trying to argue that what is secular and what is not essentially religious does not deserve the protection of Article 25 and 26. That's what he was trying to say. He was not at all trying to hammer any point to the in the sense that, okay, we have to evolve a doctrine called essentially religious beliefs, or beliefs which are essential to a particular. He did not mean all that. His plain point was that, okay, what is essentially religious is only covered by Article 25. And if you read Gautam Bhatia, his blog, he says that in some earlier judgments, the Lakshmindra judgment of 1953 particularly, the court was saying that, okay, if, for example, there is a belief that, okay, offering of food must be, food offerings must be made to the god at certain intervals. And if this ritual forms the part of the tenet of a religion, that it is protected under Article 20. Suppose in Jain religion, particularly the Digambar Jain religion, if it is the belief that Muni Maharaj, the male sage amongst Jains, Digambar Jains, if it is the belief that in order to attain Diksha, he should shed his clothes, he should be naked. Because the translation of Digambar in English is somebody whose clothing is just directions. Dig means disha, means directions. So his clothing is just atmosphere, environment, nothing else. He is completely virakt, right? So virakti, complete sannyas, no asakti, right? Now this is the part of the religious tenet. of Jainism, and therefore it is protected. Uh, Although, in my opinion, I don't agree fully with Gautam Bhatia when Gautam Bhatia says that in 1953, when such a notion of uh, religion was the part of Article 25, it was different from the latter versions. Because even in 1953, in Lakshmindra case, a tenet which is essential to a religion, the word essential was also used in 53, although it was not used as controversially as it was used later on. Now, the turning point came in the Sethi's case, Ram Prasad Sethi, Allahabad High Court judgment. I think, if I'm right, 1957. The question before the Allahabad High Court was whether bigamy amongst Hindus is a religious practice, is part of religion, is one of the tenets of Hindu religion. Now, we know that amongst Hindus there is this tradition, there is this belief that after my death, Agni must be given to my pyre, my body, by my son. So sun must, the presence of sun to continue my vansha is necessary. And therefore, if my first wife does not give me son, logically I must marry second time in order to have son, so that after my death, my remains are consigned. I get a decent burial, a burial worthy of uh, the tenets of my religion, Hindu religion. Okay. So to cut the story too short, the argument was that in order to have son, I can marry again if my first wife is unable to give me the son. And this question came before the High Court in the context of a civil servant. If you are a civil servant, you are working with the government, your first wife has not given you son, can you marry again? When you have already given undertaking, you have accepted one of as part of, when one of service conditions, when one of the conditions subject to which you are employee is that you will not indulge in bigamy, you will not marry again during the uh, lifetime of your wife. Now, court said that it is one thing to have faith in a particular doctrine. Internally, you can believe, you can entertain a particular belief. Okay, I should have son, and if I want to go to moksha, then my son must entrust me, son must consign me to flame, right? So, son must perform my last rites, so on and so forth. Okay, this is as long as it is an internal belief, fine. Internal belief can be anything. Okay, after my death, why I can't become Shri Krishna? I should become the avatar of Shri Krishna. Okay, this is my internal belief. But can you perform any external act to attain the internal belief? That was the question. Now, external act is, okay, I don't have son from the first wife, so can I marry again? Have second wife and then go for son? Now, this is the controversial point. Now, here your act is external, and although it is relatable to a particular religious belief, which may be linked with a religious tenet, with a religious doctrine, can you perform the external act? Can you, in the guise of preserving your freedom to practice, to entertain your right to religious freedom, can you perform external act in such a manner as to jeopardize the rights of your first wife, or against the law, because bigamy is a criminal law, criminal offense. It is prohibited by criminal law. Now, the Allahabad High Court took a very interesting route. Allahabad High Court asked this very interesting question using Ambedkar's speech, using the phrase essential. What is essential to religion? Which is essentially whether something is essentially religious. So, essentially religious, whether bigamy is essentially religious. That was a question asked by Allahabad High Court. And Allahabad High Court said that, look, son preference may be one of the belief. It may also be a belief that, okay, my last rites be performed by my son. But whether this practice is essential to Hindu religion, and came the conclusion rock, stock and barrel. No. There is no such tenet, at least no such tenet which is essential for Hindu religion, that your last rites must be performed by your son, justifying bigamy. So look at the sleight of hands. What was the position in 1953? What is essentially religious is protected. But now a slight grammatical sleight of hands, but look at the fundamental transformation. Now court is not going into what is essentially religious or not. Court is not going into that question. Now court is asking another fundamental question, whether a particular practice is essential to Hindu religion or to any other religion. So now you are going into the internal nitty-gritties of religion to find out whether a practice, whether a so-called practice is essential, whether it constitutes as one of the fundamentals of your religion. See the transformation, and nobody realized this transformation, probably because there was hypnotizing effect of Ambedkar on the judicial conscience as well. And because the context of the case was to prohibit a criminal offense, so nobody realized the ramification, far-reaching ramifications of this doctrine. But Ram Prasad Sethi became the origin of what is known essential religious practice doctrine. This doctrine then was further developed by Supreme Court in Qureshi's case, famously known as cow slaughter case. Court asked again the same question. Instead of going into whether cow slaughter is essentially religious, because it is one thing to say that cow slaughter is essentially religious for Muslims, and quite another whether it is one of the essential practices of Islam. Mind you, please remember, please note this distinction. As Deshpande sir used to always tell us, don't miss the point, don't miss the wood for the tree. You are asking two different questions, you are collapsing two different points. What is essentially religious is one inquiry, and whether a particular practice is essential to a particular religion is quite another question. And the second question, whether, for example, cow slaughter is essential to Islam. If you want to answer this question, you have to assume the role of Maulavi. You have to become ecclesiastical. You have to assume the mentor of Sarvajna of say Muslim religion. As if as a judge you are aware of Muslim religion. Now, if I am Hindu and if I am sitting on the court, on the bench as a judge, am I justified to interpret Islam? And if I interpret Islam, can you say with confidence by putting hand on your chest that your interpretation of Islam will be free from bias? When you cannot even deliver a judgment properly, if you had fought with your wife before coming to court. The breakfast theory, So even your breakfast affects your ability to reason. Here you're talking about interpretation of a different religion. And do you have the moral legitimacy to interpret a different religion? And on what basis? Right? But again, these questions were not asked by the court. Court simply went into the Quran to find out whether cow slaughter is a must. And it reached the conclusion that it is not. And on the other hand, it tried to emphasize the point that, okay, how cow is important for Hindus, how it is a very important religious symbol for Hindus. And the judgment was delivered again using ERP. And after 4 years from this judgment, one of the distinguished alumni of our college, Justice Gajendra Gadkar, as a final last nail in the coffin, he used this doctrine, essential religious practice, to determine two very controversial but very important questions. Who is Hindu and what is Hinduism? By using ERP, essential religious practice doctrine. Again, in between that Saifuddin judgment came, excommunication case. Daud Bohra community, the head of the Daud Bohra community has a right to excommunicate any member of its community if his conduct is contrary to the tenets of the Daud Bohra religion. Now, question was whether this authority of the Mullaji to excommunicate, whether this authority was essential, one of the essential practices. And answer came from the Supreme Court in affirmative. So even if my civil rights are affected, hukka pani ban, if I'm excommunicated, my daughter will not be married to anybody among Daud Bohra. Whatever happened to my civil rights, since it is essential religious practice to allow mullah to exercise jurisdiction over conduct of all the community members, therefore, fine, he can excommunicate. Justice Sinha wrote a very interesting dissenting opinion. And he tried to crack this doctrine, tried to question this doctrine, tried to point out the defects in this doctrine by arguing that not only this doctrine is troublesome in the sense that it forces the judges to assume the avtara of Maulavis, and it compels the academicians to be the judges, to be the scholars, to pass comments, to take judgment call on religion of others. But he also said that such a doctrine undermines the rights-based approach of Indian Constitution. Part 3 of our Constitution guarantees fundamental rights to every citizen. And if in the garb of essential religious practice, if you are supporting hukka pani ban, if you are supporting complete ban on social mobility of a certain individual at the behest of the Mullaji, then you are imposing the decision of a group over an individual. And in India, we don't have group rights. In India, every citizen has fundamental rights individually. And every individual has a right to practice religious freedom equally. The word equally is very important in Article 25. And Justice Sinha stated that this particular phrase equally, this particular term was completely forgotten by the court. Now, let me come back. Let me take you to more recent cases. The case of the police commissioner of Calcutta, Tandav Nritya case, as is popularly known. okay, we are a particular sect of a religion, Hindu religion, and according to our religion, our sect, we have to perform Tandev Nritya with trishul in our hands, with swords in our hand, and with skulls in our hands. It look very uh, ominous, right? If you do so on public place, and therefore police commissioner refused permission. Now, Supreme Court in this case held that since neither your sect is a part of religious denomination, nor the so-called practice of performing Tandav Nritya is ERP, essential religious practice. Again, court is going into the religion. Interestingly, around after 10 years later, in same facts, what happened this time? The religious book was amended. And it was suggested after the amendment that, okay, now it is a religious practice. It is essential to the performance of the sect. Anand Margi sect, I remember now. Anand Margi sect, if you want to be truly Anand Margi, then you have to perform Tandav Nritya. It was written in the book. This time, Supreme Court held, and again Justice Lakshmanan dissenting, Supreme Court held that, okay, once it is held that Anand Margi religion, Anand Margi sect does not have anything called Tandav Nritya as essential religious practice, later on you cannot amend the text of the religion. Otherwise, everybody will try to amend the text after the judgment. But see the point, in all these cases, what is happening, court is taking a judgment call on religion by reading, interpreting the texts. If you read most of the judgments bearing on religious rights, you will find court quoting copiously from Radhakrishnan. Radhakrishnan was not Sarvajna, he was a philosopher. And his point of view about a particular religion cannot be and cannot necessarily be the point of view of the people belonging to that particular religion. For example, Radhakrishnan have to say X about Jainism. Acharya Rajneesh has to say Y about Jainism. Can the court just quote from Rajneesh and Radhakrishnan and say, okay, this is what is said by these two people based on this blah, 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 and therefore X, Y, Z is not essential religious practice. Okay. Let us go further. In another case which came before the Rajasthan High Court, which was brought by a lawyer, Marwadi lawyer. His name was Nikhil Soni. He has nothing to do with Jainism. And he goes to the Rajasthan High Court invoking the banner of public interest litigation. I fail to understand. You are a Marwadi. You practice Hindu religion. What business you have to file public interest religion and question Jainism? It's like I want to go to Madras and I'm buying a ticket to go to Delhi. Right? What is the relation? How a person from one religion can question somebody else's religion? Fine. He said that Sallekhna, Samadhi Maran, is suicide and therefore it should be banned. Rajasthan High Court promptly entertained the PIL. You know, there was a lot of glamour. You're touching Jains. Jains are very rich people. It's a hornet's nest, right? So if you say anything about Jains, you will hit the headline. The lawyer will become very famous overnight. The judges will become very famous overnight. And I have to say this, that nowadays for name and fame, both lawyers and judges play to galleries. This is very unfortunate. Rajasthan High Court wrote a judgment saying that Sallekhna is suicide. Whether Sant Dhaneshwar committed suicide when he took Samadhi? Do you understand the difference between suicide and Sallekhna? And do you have the competence or caliber to interpret Jain religion as a High Court judge or as a lawyer? All that was not considered. Okay. Sallekna is suicide, and therefore it is not essential religious practice of Jains, and therefore unconstitutional. Hammer was struck. Then matter went to the Supreme Court. Supreme Court immediately stayed the judgment of the Testament. In the meanwhile, in 2008, it was realized that essential religious practice doctrine is a fatally flawed concept. It is amenable to multiple interpretations, and most importantly, for its application, you have to interpret others' religions. You have to assume ecclesiastical jurisdiction, which you can't. Now, Supreme Court in Dikshitalu case referred the matter, a number of issues pertaining to the interpretation of Articles 25-26, including the essential religious practices doctrine, to a constitutional bench. Till this date, the entire nation awaits the formation of the constitutional bench to determine the scope of essential religious practices, and in between, the onslaught of this doctrine continues. And the latest victim of this doctrine is the hijab case. Again, reductionism, sheer reductionism. They have reduced the entire debate on freedom of choice, on freedom, on individuals' belief. You have thrown everything to the caution, you have thrown caution to the wind, and you have simply reduced entire hijab debate to one single question. Although there were 4 questions in the judgment, but the rest of the questions, in my opinion, were formality. The only question which was emphasized by the court was whether wearing of hijab is essential to exercise of Islam. And again, you are reading from Quran. Again, you are trying to misquote Ambedkar. Ambedkar wrote many books. Why you are quoting only from his one book? You are misquoting Ambedkar, cherry picking Ambedkar, and you are again reducing the whole debate to a crude question whether wearing of hijab is essential. Is it an essential tenet of Islam religion? And comes the parrot-like reply, it is not. In my opinion, it is one of the most erroneous judgments ever delivered by any court. There are many dreadful judgments delivered by the courts, but I think if you want to rank dreadful judgments, this judgment would be there somewhere. Now, how do you know that I wear hijab because I am Muslim? Can you say with confidence that whenever somebody wears hijab, he or she wears the same because of his or her faith in Islam? Can wearing of hijab be justified by single reason? This point was completely missed by the court. कोर्ट को सिर्फ इतना इंटरेस्ट था, इस्लाम में है क्या, नहीं है, बात खत्म. But what about the spectrum? It's choice to coercion, right? I may have choice to wear burqa. Why? Because I want to maintain my beleaguered identity. I want to maintain my uniqueness. I want to prove that I am somebody different. Suppose I am a transgender person. I want to wear certain clothes which do not represent either male or female gender. Would you stop me from doing so? And the most important point is you're obsessed about the dress code. In how many colleges in India we really take seriously the dress code? You tell me. Put a hand on your chest and tell me. It's nothing but politicization. It's nothing but pit two communities against each other and then make the poor students scapegoats. And whether there was any legal issue, in my opinion, it was no legal issue was involved. Because overnight you cannot impose any dress code in the colleges. And even if you impose dress codes, every rule has exceptions. And the exceptions are justified by a doctrine known as doctrine of reasonable accommodation. So what is reasonable accommodation? Reasonable accommodation means you have to accommodate certain beliefs which are contrary to default, which are contrary to existing practices, which are contrary to so-called normates. So suppose the default is that girls should not wear anything. Okay, I am an individual. I am a sensitive girl. I believe I have certain beliefs, and therefore I want to wear burqa or hijab. The question to be asked is not whether wearing of hijab is essential to any religion. The question to be asked is whether my wearing of hijab is going to harm the community in general. Now look at the indulgence of the judges. They say that just as you cannot allow firearms in the classrooms, as much anything deviant to dress code is prohibited. So firearms and hijab are compared. My God, what a horrible match. You're comparing chalk and cheese. It's a radicalization. Your anger against Islam is reflected in your comparison of hijab and the firearms. But matter does not end here. The judges go further and they say, just as we cannot allow a girl, an ugly looking girl, quote unquote, an ugly woman to hide her face through mask, through some piece of clothes, as much we should not allow the hijab. So hijab is now compared with something ugly. So the association of hijab is with something ugly. Association of hijab is with firearms. What are we talking? Then question comes, okay, there was this South African judgment, Pille's case, in which the question was, Aple nakatli natni, note studs. Can a Hindu girl wear note studs when she is of age, when she attains puberty and go to school? The matter went till the Constitutional Court of South Africa, equivalent to Supreme Court of India, and the Constitutional Court categorically held that reasonable accommodation is possible because it is one of the cultural practices of Hindus to ask its girls to wear note studs. It should be allowed. That's it. Now what Karnataka High Court says is amazing. Karnataka High Court says that wearing of note stud is insignificant. It does not affect the uniform. But when you wear hijab, it affects uniform. And what affects uniform, therefore, cannot be accommodated. But what affects has impact to be accommodated. Accommodation is required because we are not compatible with the default. We are not compatible with the so-called majority norm. We are not compatible with the so-called regimentation. Right? So friends, I have learned a new understanding of reasonable accommodation and I am worried. I am very much worried. Tomorrow court may say, if a blind person go to the court saying, please give me reasonable accommodation, I want to teach as a as a professor in the college, and I want the support of computer, they will say computers are too expensive. Or if you use computer, then you will become a semi-human being, because it will be a combination of machine and man, whereas only men or women should teach. Who knows? Because we are getting new lessons of wisdom from the judges, right? So my point is, from bad to worst, the journey of essential religious practices is from bad to worst. Only one judgment which needs appreciation vis-a-vis essential religious practices is a judgment delivered by Justice O. Chinnappa, who was a born communist, who did not have any faith in any religion whatsoever, Gnostic. And the question before him was whether the Jehovah Witnesses should be compelled to sing national anthem. Although they stood respectfully, their only concern was they cannot use word of mouth. They cannot use their mouth to appreciate any other deity except their own deity. So that was closely associated with Jehovah Witnesses religion. Now, if you are a nationalist like the Kerala High Court judges that time, they said, nothing doing. If you don't want to sing, get out of the school. No accommodation. Coercion. My way or highway. Either you are here or you are not here. Dichotomy. Justice O. Chinnappa Reddy gave a peace of mind to these buggers from Kerala High Court, very clearly telling them, don't be judgmental about anybody else's religion. If you judge others, they will also judge you. हर एक का घर शीशे का होता है. Everybody lives in glass houses when it comes to religion. And very categorically he held that logic has no place when you interpret any religion. Common sense has no place. Common sense से जाएंगे तो क्यों भाई मूर्ति पे क्यों दूध डालना? It is against common sense. You are wasting milk. बोलिए आप शंकराचार्य को जाके क्या होता है देखिए फिर. Therefore, to cut the story too short, essential religious practices is a monster, is a genie which often comes to haunt us, which often comes to haunt the constitutional doctrines, the interpretation of Articles 25 and 26. And in my opinion, sooner we leave this doctrine, better it would be. Because our constitution does not allow to interpret part 3 in silos. When you try to interpret article freedom of religion through the lens of ERP, essential religious practice doctrine, then you don't go for integrated thesis. What is integrated thesis? After Maneka Gandhi, the integrated thesis is that when Article 21 is violated, it also amounts to violation of Articles 19 and 14. Similarly, I can argue when Article 25 is violated, it also amounts to violation of Articles 21, 19 and 14. How? It is compelled speech. When you ask me not to wear a particular cloth of my choice, it is a compelled speech on your part. You are imposing your thoughts on me. When you are asking me to believe that hijab is against the dignity of women, you are constructing a particular imagery of women. You are trying to impose the Hindu women construct on me. Why I should believe you? Similarly, arbitrariness. Overnight you come with a dress code and you say, okay, from tomorrow this is your dress code. And you know the most important, and this is the climax of my talk, I'm going to stop. See the irony of essential religious practice doctrine. Court says that this is not a well-established doctrine. Now, The other side quotes from the history, okay, from 7th century, it is there. Women used to wear burqa. They said that, okay, that was a different context. So, see, you are trying to have it both ways. On one hand, you are saying the doctrine is not old enough to be recognized as essential religious practice. And even if it is brought to your notice that, okay, it was practiced in 7th century, you are saying that the reasons for which it was practiced are no longer relevant. So you are engaging in rationalization of reasons. So again, the judges of the High Court are becoming Shankaracharyas. The judges of the High Court are becoming the Maulavis. The judges of the High Courts are becoming Pandits. In my opinion, they are violating one of the features of the basic structure of the Constitution, secularism. It is none of your business to either become Maulavis or Pandits and say that, okay, this is right and this is wrong. This role has to be performed by legislature, which represents the population. You are unelected judges. Your moral legitimacy will be diminished if you try and brand a particular practice the way you have branded the wearing of hijab. I don't see any logic either in the rhetoric of majority that, okay, if Muslim girls wear hijab, it will be pollution in the institutions. We have already a lot of pollution in educational institutions. And there are many other important issues than hijab, which should invite our attention. Therefore, while concluding, I would end by saying that this judgment should have been on the planks of Articles 21, 19, or 14. Alternatively, if one were to agree with Professor Farah Ahmed from Australia, Melbourne University, her argument was that this case did not involve any constitutional issues at all. This was merely an administrative law case, whether the legislature had given any mandate to the government officials to issue the GO they issued. So whether the GO was ultra virus, the parent statute. So the case was merely the case of ultra virus, right? I don't want to be judgmental. I leave it to you how you look at this case. I pray to God, G capital, in a very secular sense, that good sense will prevail with Supreme Court, and Supreme Court will entrust, or Supreme Court will perform the last rites over this doctrine when matter reaches for final hearing. I thank the department for allowing me to, speak to my mind. I must very honestly confess that I was not able to read the boring 129-page judgment of the Karnataka High Court, and it is a punishment, in my opinion, to read such a long judgment. Judges don't deserve such important time of professors. They should realize, if you want us to read 129 pages, have some substance in those 129 pages. Otherwise, it's a paper pollution. You could have written a 40-page judgment and you would have said what you wanted to say. You are showing your scholarship. You are quoting this scholar, that scholar. This is not the way judgments ought to be written. Deshpande sir used to say, expose these judges by writing alternate judgments. So I would suggest the department to write a 30-page judgment and send it to Karnataka High Court. Right? On this note, I will pause. Thank you. Thank you very much.
Thank you, sir. It's a very appreciable suggestion. But I would like to start Q&A session with you.
Yes, thank you so much, sir. Sir, we have few questions. If you permit, may I ask?
Yeah, one or two questions we can take. Yeah.
Okay. Sir,
Let's
the
see.
question is, children are beyond any religion till the time they understand it. Then why constitution or law imposes religion on them by their birth?
Well, Constitution does not impose any religion on anybody. In fact, Constitution allows you to be either religious or irreligious, right? Constitution merely says that if you want to practice your religion, you are free to do so. Right? So don't entertain this wild thought that Constitution imposes religion on citizens. It doesn't.
Thank you, sir. Sir, we have another question.
Yeah.
What is understanding of religion under constitution, and what is the position of religion under secular constitution?
Well, it is not easy to uh, uh, it is not easy to really define religion, and lot of ink has been spilled over lecture. So we are not in a position to define religion, but nevertheless we may say that religion is a cluster of doctrines and beliefs which regulate our conduct, and religion is something which is a kind of impulse. Under the impulse of religion, we tend to do things which we would not have done. Religion also creates a fear. I think if anything, if probably Putin was in India, he would not have done what he has done, because he would have definitely been afraid of God, right? But Putin, being communist, unfortunately, he does not believe in God. So uh, Putin uh, should be brought to India, in my opinion, and he should be trained in Hindu religion. Probably the war will be ending. And your question about the religion in secular constitutions. Well, every secular constitution must be neutral. But at the same time, constitutions in diverse societies, constitution with in deeply divided societies must treat every religion equally. It is not easy for a state with deeply divided society to maintain equidistance with religions. You cannot maintain, because religion pervades almost every aspect of our life. But you have to treat every religion equally, and as far as possible, state must maintain neutrality.
Thank you, sir. Due to time constraint, we'll take last question, sir.
Yeah.
Sacrifice of human being or animal to offer to an idol or god in name of mannat or practice of devdasi, can it be called as essential religious practices?
Not at all. In fact, public order, morality, and health, these are the three important constraints subject to which only freedom of religion can be entertained. And legislation banning human sacrifice, or legislation banning even the sacrifices of animals, can be justified under public order, under morality, or under health. And there is no need to, in fact, invoke doctrine of ERP. You will be textually correct, textually upright, if you use the language of Article 25 rather than invoking the fiction of ERP. In my opinion, ERP is a fiction. And on the other hand, the language of Article 25 and 26 is the reality.
Sir, you are not audible.
Hello? Yeah.
Yes. Thank you, sir.
Yeah.
You are audible now.
Yeah.
Sir, if you allow, we have a few questions.
Okay, maybe one or two questions more. Yeah.
Uh, okay, sir. Sir, the question is, how will the Uniform Civil Code assist in thwarting caste or religion-based Indian society?
Till you annihilate the caste system, which was the desire of Dr. Ambedkar, right? You quote Ambedkar for everything other than the annihilation of caste, right? You don't feel shame in saying that Sushil Kumar Shinde was the first Dalit chief minister. You don't feel shame in saying that Abdul Kalam was the first Muslim missile men, whatever, right? So no matter what code you bring, till the caste system is there, till it is not annihilated, nothing will happen. Uniform civil code, in my opinion, is a dead duck. The intention behind uniform civil code was different, but its politicization has made it a very blunt instrument. I don't think it can be any longer pressed into service.
Thank you, sir. Sir, another question is, if secularism says state has no religion of its own, then
Hello.
funding of public money towards the or promotion of particular religion isn't a violation of secularism?
Well, Article 27 very clearly says that no tax may be imposed to promote a particular religion. But nowhere Constitution says that state should not provide assistance for performance of such religious ceremonies which are also culturally significant, culturally important. So sometimes, for example, the 2500 birth anniversary of Bhagwan Mahavir, it is not merely a religious ceremony for Jains, but it is also one of the cultural milestone. So culture and religion many times is very uh, uh, intricately intertwined, right? It's a complex blend. Uh, for example, when you go for Jirnodhar of any temple, temples are not merely the places of worship of particular religion, but they also signify the cultural heritage, right? Yes, when it comes to very particular things like, providing subsidy to perform, to go for Hajj, those or for example, if the government gives money for going to Tirtha Yatra, I think these are controversial issues, and these issues should be looked with jaundice eye. But when it comes to protecting symbols or celebrating the general festivals, which are both cultural and religious, uh, as long as government is not discriminatory and government is able to help all the religions, I think there is nothing wrong in government funding.
Thank you so much, sir. Here ends the
Yeah.
question and answer session. Now I request Dr. Girish Kulkarni, sir, to give the formal vote of thanks. Over to you, sir.
Am I audible?
Yes, yes, you're
Okay.
audible.
I'll, after this enlightening and of course a very interesting, enthusiastic session over the very controversial topics of religious adjudication as such in the form of essential religious practices by Dr. Sanjay Jain sir. Uh, on behalf of Postgraduate Teaching Department of Law, I would like to express the deep sense of gratitude towards Dr. Sanjay Jain sir that he graciously accepted to share this session and share his expertise and knowledge in this field with our participants. I'll also be very much grateful towards the head PGT Department of Law, Dr. Payal Thaure ma'am, who allowed us an opportunity to organize this webinar on the very relevant and current issues where even the students were also desiring some legal clarities on this issue, which unfortunately was not able to get from the judgment as such. Then I will also like to thank to organizing team and the technical team without whose assistance this webinar could not have conducted. I would like to thank all my colleagues and to all participants for joining here for all. Thank you. Thank you, sir, for sharing your time and energy with us on this topic. Sir, Sanjay Jain sir.
Thank you, Girish. Thank you, Bhavya madam. Thank you.
Thank you, sir. Thank you
Yes,
so
sir.
much.
Thank you.
Thank you.
Really
Thank you.
interesting session, and of course, in line.
Yes,
Girish,
yes.
your voice is not audible properly, actually. It's breaking.
Yeah, it's breaking.
Yeah.
Okay, okay. Sorry for the troubling, but thank you, sir, once and all.
Thank you. Thank you.
Participant, we have shared the feedback form. Kindly fill it.
Madam, बंद
Favorite करत होता का? Okay. काय माहिती, मी ते इथं दाबून ठेवलं होतं म्हणून उचलतो. Mic सुद्धा आहे का? Mic बंद करा. Is it on mute? हाँ, ये डायरेक्ट कैसे करते हो वो पता नहीं. Currently continuous
स्टार्टिंग में मैंने डायरेक्टली ये करवा के दिया था.
हाँ तो माझा पूर्ण
Girish, kindly mute yourself. Girish, please mute yourself.